Hello, welcome back again to the business law course. This is the second part of the labor law topic. At the previous part in the labor law topic, you have learned about the concept, and now we are continuing by understanding two main relations in labor law. Nevertheless, before we continue by seeing the two main relations one by one and make the comparison between them, I think I need to deliver you some main terminology to understand in this topic. And to support you in learning about this topic, you are suggested to open and read the legal basis, the Indonesian law that govern about the labor law in Indonesia, which is in law number 13, 2003, concern on manpower or labor law in Indonesia. So the first main terminology is manpower, or in Indonesia we call it ketenaga kerjaan. If you try to find the Indonesian, I mean this law in English version, some translation also use the terminology labor. So what is manpower or labor or ketenaga kerjaan in Indonesia? It is everything referred to the matters that is related to people who are needed or available for a job before, during, and after their employment. So it's still related to our previous discussion that labor law is regulations regarding the workings before, during, and after the workings. So manpower affairs or labor here is talking about all of that. So it's talking about how is the legal recruitment, how is the conduction of the working agreement, and how is the settlement of the termination of a contract, what what are the obligations of the employer to fulfill towards the labor after the agreement is finished, something like that. And the second and the third one, which is quite close and similar, is people available for job. And the third one is a worker or laborer. This one, the people available for a job in Indonesia, we call it tenaga kerja. And this one is pekerja or buruh. So what's the difference? So the difference is people available for job is every individual or person who is able to produce goods or services for other party. Or on the other word, people available for a job is every people that is qualified to work. So remember, they are qualified to work, but sometimes they already work, but sometimes they're already not working. So if you are now, let's say, 23 years old, you already graduate from university, so you are people available for a job. But you would be called as a worker or a labor when you already committed to do a certain job. So a worker or labor is every person who works for a wage or other forms of remunerations. So if I am graduated from my university but I'm not working, I am people available for a job. But when I already got a job then I am a worker. If I'm not going to university, just graduated from high school, I work, then I am a laborer. I am a worker. Okay. So these are three first terminology for you to understand. And the next one is the employer. This is the opposite of the employee. If you're a worker, you are the employee. You work for a certain party called the employer. Okay. And you also need to read many other basic terms in Article 1, Law 13, 2003 regarding the manpower. But this four is the main one that we are going to use in this discussion. So back to the main part of this topic, the two main relations in labor law consists of working relations and industrial relations. So first one is working relation. So working relation is relation between the employee and the employer, or the worker and the employer or the entrepreneurs. Let's say this is the employee and this is employer. Maybe this is you, maybe this is a company, maybe another person. So there is a relation between the employee and the employer. This relation is based on a contract. Yeah. So this kind of relations only occur because both parties agreed to commit themselves into a certain consensus that is provided in a contract. So we call it working agreement. So based on this working agreement, now there is relations between employee and employer that occurs right and obligation for both parties. Let's say that you're working for a company. So before you work, of course, there will be some process, which is the first step. And then one of the process maybe is including interview. So you are going to be interviewed by the candidate of your user. And in the interview and the discussion, maybe you are all going to discuss about the wages as well. And the other terms, including in what position you will work, etc. And those kind of consensus between you and the employer, it's just a working agreement, whether it is written or not written. Remember, contract can be written or not written. And based on this contract, based on this agreement, you know your right as the employee. So how much wage I get? And do I get any facilities? Do I get some housing facilities, vehicles? And is there any bonus, something like that? It's all based on the working agreement. So that's your right. And what is your obligation? So your obligation based on the working agreement is talking about what should you do in the job and in the company. Are you a manager? Are you a staff? Are you a supervisor? Or are you just a regular staff? Something like that. And this kind of right and obligation is also attached to the opposite of yourself, which is the employer. That the employee has the right upon you, that they have to make sure that you do your total service to them based on the agreement of the contract. I mean the working contract. And also they have obligation to you to pay you money as the wages, giving you facilities, give you some day off, and also remember again after you are retired or maybe there is a termination by one side of conducted by the company, then the company maybe should pay additional money, exclude the money that already governed by the law, like the severance money and reward money. So maybe in the contract, in the agreement, you can also talking about any other compensation after the working is finished. So what is the working agreement, working relation then? So the working relation, the point is the relation between employee and employer based on a working agreement. And based on this working agreement, both parties know what their right and obligation in the labor conduction. And based on this working relation, both parties is also expected to follow the regulations of working both in Indonesian law in general or the company's regulation. The second relations is the industrial relation. So industrial relation is a three-side relation among the employee or the labor, the company or the employer or the entrepreneurs, and the government. So in working relation, only employee and employer, but this one is three sides relationship. So to make sure that the right of employee and employer is protected and both parties is conducting the labor relation or the working relation is based on the law, so the government exists to interrupt and also to supervise the relations between the employee and the employer. So there will be no employee that treated unfairly, or maybe they are asked to work too hard, yeah. Just like maybe you watch in television, some Indonesian labor is treated so badly in other country, in Korea, they work in a certain shift, something like that. So this is the existence of the government here to play at least two roles. The first one is the regulator. Second one is as the supervisor. And sometimes government also play a role as the third party, as a mediator sometimes. So regulator means the government make regulations regarding the labor law. So the employer and the employee must follow it, must follow what the government said, including also about the business licenses during the working, and also as the supervisor to make sure that the conduction of the working relations between the employee and the employee is not against the law or any public order. And also sometimes when there is a termination of contract by one side, like in Indonesia, PHK for example, pemutusan hubungan kerja, only by one side, termination of contract here. And especially nowadays, yeah, in COVID-19 situation, many companies is falling down. They have to be bankrupted, and some of them have to do this one, PHK, termination of contract to the employee. So they have to settle this kind of termination by paying what the regulation said that the company must pay to the employee if they terminate the contract by one side. So the government should be there uh, to supervise and regulate. And sometimes, if the employee and the employer cannot finish this problem, for example, the company terminate you, and based on the regulations in Law 39 2003, after you calculate the compensation, it should be 200 million rupiah, for example. For example. But the company doesn't have enough money, or maybe actually they have enough money, but they don't want to pay that much. They say we only will give you 100 million. So what will you say as the employee? If you just accept it, so there will be no problem. But if you doesn't want to accept it because you know based on the law you're supposed to get 200 million, then you can take legal action. But before that, you have to follow several um, procedures, which one of them is including the government to be the third party to help you and the company to mediate you to discuss again how to find the best solution between you and the employee. So here the government access Dinas Ketenagakerjaan, for example. So the Bureau of the Labor could try to help the both parties discuss. But if you both parties doesn't want to settle it by the discussion, then you as the employee, maybe you can sue to the court. So here, the court is also the government, and in this position, the government or the court is the enforcer of law. So in this case, the court or the government is the law enforcer of the labor law, and they will settle how is the case should be. So this is to tell you that you as the employee and also the employer, you must be abiding with the government, the regulation, and also you have to involve the government first before you sue to the court, whether you're the employee and the employer, because sometimes the employer can also sue the employee if they don't perform. And if you cannot settle it by mediation, then you can go to the court. So that's why the court names in Indonesia is industrial court. Pengadilan hubungan industrial. Why? Because when it goes to the court, so it's not only the problem between the employee and the employer, but there is also government here to enforce the law. So that's why the court name is industrial court, because this is now talking about industrial relations. Okay. Try to read again about it. Try to read the law, the regulation about it. And hopefully you can understand it, because this is very basic. This is very main part for you to understand about the labor law before we continue to the next part. See you at the next part. Thank you.